Well, welcome to the Entrepreneurial Edge series. This is part of an overall series that's put together by a joint venture of UAA, the College of Business and Public Policy, Alaska Pacific University, and University of Alaska Southeast. There's a common interest group that organizes these events, including a lecture series and Entrepreneur Boot Camp and other activities. So welcome. Today's event is a talk by Professor Helena Wisniewski. Although I'm calling her professor, but she holds many titles. She's a very accomplished person. The subject for today is patenting, licensing, and intellectual property, which is very much her bailiwick. And she's a very accomplished person. I have a formal introduction of her for her, but I think probably the most impressive thing about her right now is she's about to embark on winter number 2 up here. And the first winter is that's the one that really scares people off. So if you make the first one and you've started into the first month of the second, then that means that you're a hardy soul, you've made it, and you're likely to persist here. And at the university, we're really interested in persistence and retention and such issues. So let me formally introduce Dr. Wisniewski. So her formal title here is Helena is Vice Provost for Research and Graduate Studies and Dean of the Graduate School at the University of Alaska Anchorage. So she's a Vice Provost for Research and Graduate Studies. She's the person, the central person when it comes to organizing our entire research effort. She's also Dean of Graduate Studies, and she's also a Professor of Entrepreneurship with her faculty appointment here in the College of Business and Public Policy. She brings with her a wealth of experience. She has had a long and distinguished career. She's been a senior executive. She has a breadth of experience in academia, the private sector, and the government. And she has an impressive record of leading research and technology innovation, new business formation, business incubation, and so on and so forth. She's a technological entrepreneur who has successfully launched no less than 10 startup companies. So that's quite impressive to launch no less than 10. I understand that launching even one is stressful. So I think that it's not surprising that she's able to persist here in our Alaskan winters. Her academic experience is enhanced by leadership positions in industry and government. She's been a vice president for Titan Corporation, senior executive at Lockheed. She was the CEO and chairman of Aurora Biometrics. And you know, the CV is long, but again, I've been told that when you introduce someone, a distinguished speaker, don't just make the introduction as if it was reading their CV. I've also worked closely with Helena, and she's a consummate professional. She has an encyclopedic knowledge of a variety of issues, and she's really well placed to help lead the effort to really catalyze the research that we do here at the university and to explore its commercial applications. So she's very well versed, and she'll probably make reference to any number of the involvements she has. So I'll make this introduction short, and I'll ask you to give a warm welcome to Dr. Helena Wisniewski.
Well, it's a pleasure to be here, and thank you for that really nice introduction. Can you just lower the lights? That way, don't go to sleep, but that way it'll be a little more vibrant on the screen. But in terms of long and cold winters, that's really great for me, because what he didn't say is that I do dog sledding for my winter sport. So last winter was the best winter ever for me. So hopefully this winter we have a record snowfall again. What I was asked to talk about today was innovation and invention, but in terms of patents and licensing and why they're important to a business plan. And because this is Global Entrepreneurship Week and we're emphasizing innovation and invention, I'd like to start off with a question of an inspirational example. He was an inventor and an innovator. He was featured on the cover of Time Magazine's 9th annual special history issue. His influence, even though he lived in the late 1800s, early 1900s, his influence is felt today in our everyday lives. He was #1 person of the top 100 people of the millennium. Who wants to guess who it is?
Edison?
Yes, very good. Exactly. It's Thomas Edison. And of course, I'm proud of that because he's from New Jersey, and so am I. But anyway, inventors like Edison, and the reason I'm picking him for Entrepreneurship Week is not only because of his accomplishments, but particularly his inventions actually launched on General Electric, which is a famous electrical company, recorded music industry, and motion picture industry. And among his thousands of patents was actually one for an electric car. So an electric car isn't really a new idea. It's been around for a while. He created jobs. Okay, also a nice byproduct of invention and innovation is creating jobs. He created jobs for 13,000 people in his New Jersey lab. And one of his real geniuses was actually to bring people together in interdisciplinary efforts. Whoops. So my presentation today will actually focus on protecting intellectual property, the benefits of patents, and then I'm going to wind up with our new commercialization infrastructure here at UAA. Well, for intellectual property protection in your business plan, it's very important because it influences your business model, it can influence your exit strategy. Very important is that it's a valuable asset and it's your chief commodity to create a barrier to market. And I'm going to give some examples about patent wars today, which will really uphold those three bullets. And when you're thinking about your business model, you should really think about it with respect to patents. And as I'm going through my presentation today, if you could, whoops, if I could master this, that would be a good thing, okay? To think about the following is that with respect to patents, the old model was really that patents protect your products. But we're really looking at a new model today that patents themselves are the product. So think about that as I'm going through some examples and the presentation today. So whether you're an inventor, an artist, or a writer, there's different ways to protect your intellectual property. And intellectual property could be a brand, an invention, a design, a song, or another creation. Intellectual property can be bought and sold, and the ways to protect it are either with a copyright, trademark, trade secret, or a patent. So copyrights are used to protect literary works, dramatic works, musical works. Once you've written something down, technically it's already copyrighted. However, if you ever have to go to court and have a litigation, then having it registered is really important. So a trademark is another way to protect a different kind of intellectual property. And trademark is a distinctive sign or indicator used by an individual or a business. And really it's to show that what they're marketing or what their product is, it's coming from a unique source designed for a specific market and distinguish its products from other entities or products in the market. So Lego, if you have children, Lego is a very famous branding and logo, and it's trademarked. Starbucks is the other one, and you could see the little R down here in a circle. That means it's a registered trademark. So there again, you could trademark and just put a TM and say that's my trademark, but if it ever went to court that someone was infringing on your trademark, then to have it registered is a good idea and beneficial. Oh, well, I sort of gave it away. But different from a trademark where you're really protecting either a picture or a word or a phrase or a title, a trade secret is you want to protect a formula. And it's a form of, it can be extended indefinitely, and that's an advantage. And that's an advantage over patents, which only last for 20 years. So my big question was, what famous company has a trade secret and never has had a patent? And you saw the answer. It's Coca-Cola. And I was surprised when I heard that because one would think, well, certainly they would patent their idea. But Coca-Cola has been very effective in protecting its trade secret. And as I said, it lasts much longer than 20 years. But the bad side to a trade secret, or the downside, is the fact that you don't have the protection. So if someone reverse engineers, which you have, then you don't have the protection that a patent affords you, where you can take them to court again and say, you've infringed on what my invention is. Now, how do you protect a trade secret? Well, one way is you don't let a lot of people know what it is. So usually they restrict the key information to 1 or 2 trusted individuals, and you have non-disclosure agreements with your employees, and that's very important. So patents. Patents are an asset that can be invested in directly, and the advantages to patents is that you obtain a return on investment from licensing. It's really important in terms of litigation, and it's a real leverage during negotiations. A patent can be sold, licensed, mortgaged, assigned, or transferred. So business strategies around patents, they involve not only protecting what the product is, but also on protection for concepts that you have. So they go beyond actually the actual product. And they can lead to an actual focused R&D program. So I know quite a few companies, in fact, I serve on the board of directors of one, where their strategy for their research and development is really focused around their different patents or inventions. And I'm going to share some cases later that illustrate the value of properly developed patent portfolio as an asset. Keeping in mind, though, the following: a patent is not the right to practice or use the invention. Okay, a patent actually provides the right to exclude others, and that's the really key point, that it excludes others from making, using, selling, offering for sale, importing the patent and invention. Okay, so in the U.S., you have protection for 20 years from the date of the original filing. And so in some ways, the patent can be viewed actually as a legal monopoly. Well, interestingly enough, that a patent doesn't necessarily give the patent owner the right to exploit the patent. Okay, so many inventions are improvements that depend on prior inventions. And so if you look at the example of a mousetrap, that if you built a better mousetrap, then in order to sell your mousetrap, you would have to consult the person and get their permission who invented the original mousetrap before you could do that. Otherwise, you could be infringing on their patent rights. So the thing to keep in mind is that if an inventor obtains a patent on improvements to an existing under patent invention, then they need permission from the owner of the original invention before they can actually build the improved invention. What is patentable? So novelty and non-obviousness are conditions for getting a patent. And that may sound obvious to you, but as you're actually writing up your patent application, you have to really make sure, so you have to look at prior art, and you have to make sure that you're not imitating the prior art. And keep in mind, you can't patent an idea. It's an invention that you're actually patenting. So to be an invention, you need to know how to implement that idea in a world product. You don't have to build the world product, but you have to know how you would go about building it. Or you need to describe it so someone else can actually build it. And that's very important. So on the negative side, an invention cannot be patented if the invention was known or used by others in this country or in foreign countries. And very key, and this comes up a lot here at UAA as well as other places, that the invention was described in a printed publication in this country or a foreign country, or in public use, or on sale more than 1 year prior to the application. So that 1 year time frame is really very important when you're filing your patent application. Well, in the US, only the inventor can apply for the patent, with some exceptions. If the inventor is dead, then their estate can apply for the patent. But it has to be the inventor or an exception like that. If one or more inventors are involved, then it's a joint patent, and they file for it as joint inventors. If you're doing a startup company and you have an investor and you come up with a patent, that does not give the investor the right to be an inventor on your patent, okay, unless he was really a part of it. So just investing in a company doesn't make you an inventor in inventions for that company. Well, there's different types of patents. Utility patent. That's probably the most common patent. In fact, 90% of all patents are utility patents. And it's issued for the invention of a new and useful process, machine, manufacture, or composition of matter, or a new and useful improvement thereof. So, and as I said earlier, it excludes others from actually building, which you have. And 90% of the patents are utility patents. Design patent. Now, this is going to become very interesting as I get into some examples about what's been happening in patent wars. But a design patent has gotten more attention lately. And it's issued for a new, original, ornamental design for an article of manufacture. So I won't give it, I was going to give an example now, but I'd give away some of the punchlines later on. So you can't, it permits the owner to have the ability to prevent someone else from copying their design. A plant patent, I won't dwell on these, but there's 6 total patents. But a plant patent is actually issued for the development or inventing a totally new plant, and there are certain conditions for that. A reissue patent to correct an error in an already existing patent. And what I'd like to move on to are some patent application elements. So what do you need to include in your patent? Well, you need a description of how to make and use the invention with enough detail that a person skilled in the art or technology can actually make and use the invention. You need drawings to illustrate the invention. So how detailed you make those drawings really depend on your invention, but usually an attorney can find somebody to help you draw those up. You need one or more claims, and this is probably one of the most important things because your claims are really what the patent is about. Okay? They are what you are seeking to protect. And you need to know if there's any prior art, if that's applicable, and you need to state that in your application so that the patent office knows that you know what existed before, and also you can differentiate what you have from what has already been patented. As soon as you file your application, you can call it a patent pending. So on a lot of products you pick up, you see patent pending on it. That doesn't mean they have the patent, it just means that their application is filed and under review. Well, less expensive and less arduous to create are provisional applications. And so provisional, you don't need to have the claims, but you need to have a good enough description that when you do the non-provisional patent application, that those claims will build from your provisional patent. So it requires a written description of the invention, drawings, and you can also say patent pending once you do it. Now, a non-provisional application must be filed within 12 months after the provisional application is filed. Another benefit of doing a provisional application, you've actually established an early effective filing date for a patent, and you avoid a pending statutory bar to patentability. And what you do is actually you can extend your time by 12 months in effect, because 12 months after you file the provisional application, you file your patent application, your non-provisional application. And so the patent end term is actually extended by 12 months because the date is the one effective of the non-provisional filing, of the provisional filing rather, not the non-provisional filing. So it can be viewed as an interim step, and this is also very helpful on the road to a patent, because you should consider it as soon as your invention is concrete enough, that you're intangible enough that you can describe it. So if you want to improve on it, or you want to add some more, you want to add claims to it, and you want to test it out a little bit more in the lab, once you do the provisional, at least you've now gotten some protection. Well, effective March 16, 2013, the U.S. patent system will change from a first to invent to a first to file system. And that's really going to be a big change, because under the current law, if two patent applicants claim the same invention, the patent office does a special procedure to determine who invented first. And now who invented first gets the patent. As of March 16th, that changes. So if two persons make the same invention, the inventor that filed his application first gets the patent. So a provisional patent now becomes very interesting and more valuable in a sense, because you can get that out more quickly than the actual patent filing. But now you've nailed down a protective wrapper around your invention. Well, what about the power of patents? One of the things I was asked to do, I want to lay some groundwork about what they were and some of the definitions, but what I was asked to do is to build a little bit of a case as to why you should consider it when you're writing up your business plan. Why is it important in the business plan or your business model? And as I pointed out a few minutes ago, that it becomes an asset, right, that you can sell, you can leverage. And if you're doing a startup company and you want to acquire investors, then one of the things they're going to ask are, what are your assets? So if you're a new company, then if you have patents and you don't have any customers yet, that becomes your primary asset. So, but what about what's going on in the world today? Well, it's kind of interesting. On August 12th, a jury found that various Samsung products infringe on a series of Apple patents on mobile devices. So what the verdict said was that Samsung violated a series of Apple's patents related to the software, but also the physical design of the mobile devices. So when I mentioned that there were two types of patents, a utility patent and design patent, here's an example where the design patent was really important, because it was the actual physical design of the phone that was also contested, as well as some of the other physical attributes. So Apple's patents were all valid. Apple didn't do any violation of Samsung's patents, so Apple was awarded $1 billion in damages. So when I said they become a valuable asset, they certainly do. In this particular courtroom case, the victory really signals a couple of things. That it's a powerful lesson that patents aren't just for technology anymore. So 3 of the 6 patents that a jury found Samsung had violated were the design patents. So now, not how it functions, but how it looks became very important. Let me go to... So what I want to, let me kind of allude to some of those. But what's happening here, and I'm going to get to another example in a minute, is the fact that many times companies will have a patent and then buy up patents from other companies, not because they want to use the patent, but because they want to prevent the other company from using it, or they want to remove the competition from the street. So that's why patents also are important to your business plan, because you can use them as leverage, or you can sell them and increase your revenue stream. Well, in April 2012, the Wall Street Journal cheered AOL's deal to sell $1 billion worth of patents to Microsoft, sending the internet pioneers' stock soaring over 40%. So now we see another benefit. So because AOL was able to cut this good deal, got $1 billion for a lot of its patents, now its stock value soared. So that was good for shareholders as well as the company. So for Microsoft, the deal highlights where the technology companies are willing to pay large sums in order to bolster their intellectual property and protect themselves. And I was one of the examples. So based on what I've been saying, what do you think is the latest high-stakes technology conflict that patents are involving today?
Extortion.
Yeah. Well, that's a good answer. What else? But what particular product lines? What's the big deal?
Social media. Samsung and Apple.
Well, closer. It's actually between iPhone and Google. So it's the iPhone, well, Apple and Google. It involves the iPhone and the Android. And you could see where some of the similarities are in the phones and the contention over some of the suits. There's your Android and there's your Apple. So in August 2011, Google paid $12.5 billion for Motorola's smartphones and its 17,000 patents. And that $12.5 billion is one of America's creative companies will not use it to actually innovate. Okay, they're not going to innovate with that or hire anyone besides lawyers to do some of the litigation. But the point is that Google wants an arsenal of patents to fight a similar arsenal collected by the competition of its Android. So what they want to do is limit the competition that they have, so they want to buy up all the patents that the competition may have. So it's another way that patents are a very valuable asset and even becoming more so. And just to continue the patent wars, Apple and Microsoft recently teamed up to buy 6,000 wireless patents for $4.5 billion from Nortel. And it wasn't that there was such exceptional technology there, but they wanted to keep Nortel off the street. So one way to do that is to buy up all the patents. So as we're seeing that patents are very popular because they can provide both offensive and defensive weapons. So in addition to having a company asset, they're now being used in patent wars as weapons. And what the last bullet, I'm going to just dwell on that for a second, because when I said I want to connect it back to your business plans, well, the value of a properly designed patent portfolio is really a big business asset, however you're going to use it, either to keep the competition off the streets or to improve your competitive advantage in other ways, or technology value, or to prevent someone from infringing on your design. So basically, that by focusing not just on the innovations, but under the underlying concepts of those innovations and implementing a strategically valuable protection plan for those concepts, that's what makes a business plan really valuable, or one of the elements that becomes very valuable in it. So when I started the presentation, I had mentioned to keep in mind, are we seeing a shift in the purpose of patents and the business models? And the old models, the patents protected the products, and new models, it seems that the patents are becoming the products. There's another little problem with patents, not that anything I've said up to now was necessarily a problem, but there is an issue in the way the current patent law is written, in that if you're building on someone else's invention, you're in danger of not being able to market your product unless you get their permission. However, with software, the way you create software, as many of you know, is you are building on a previous component or invention. So a lot of the patent laws or rulings aren't really accurate or well-formed to actually protect the software. And a good contrast to software is how advances are made in the pharmaceutical industry, which is made up of largely independent areas of research. So when you're creating a pharmaceutical product, you're very different from someone else's pharmaceutical product. Unlike software, you're building on something that was created previously. Well, the big war between Apple and Google is a patent war, but patent wars are not new because patent wars actually go back to, and I thought this was kind of interesting, Eli Whitney and the cotton gin. So even back then, Whitney and his partner brought many suits in the 18th century to protect the market of the cotton gin. And then Thomas Edison regularly used patent challenges and litigation to attack competitors, and to attack competitors actually to secure General Electric's future. So the idea of using patents to do that is not a new idea, but I think the price stakes have really escalated. So at this point, are there any questions on the value of patents and assets? And then I'm going to get into what UAA is doing in commercialization.
I'd like you to comment on when I said extortion earlier. We've got the companies here that are using patents to battle against each other, pro and for and against. But there are also large investment groups that have nothing to do with technology that are buying up thousands upon thousands of patents and then going out to all these high-tech companies and extorting money out of them by selling them patent insurance. That we own these patents, and who knows if you've infringed on any of the patents that we own, but we're going to sell you an insurance policy, almost like mafia protecting your car from getting scratched. Could you comment on the extortion aspect of these patent wars?
Well, the examples I gave, they're not really doing that. They're more collectively, and in some cases, the companies are joining up to keep competitors off the street. So they're not extorting it that way. But I'm not sure what you're asking me. How I feel about it, or?
Yeah, I mean,
I don't think there's anything you can be able to do to prevent it.
Not necessarily prevention, but I mean, we're coming on the patent war situation between companies, and now here are totally third parties coming into the fray with not creating any new product. They're strictly lawyers, being greedy, and they're vultures.
And I don't think it's going to get any better necessarily. And now it's even included our auctions. So, and it's more in the theme that you're talking about in a way, although it could be useful if you have a patent that's winding down and you want to make something off of it, going to an auction is beneficial. But, it's kind of more the concept where it isn't really building someone's business or their product or protecting a patent. So which the whole intention was really created to do, was to protect your invention or protect someone else from building your invention. So what you're saying seems almost contrary to that whole concept.
It is, but it's unfortunate.
And I don't know if anybody is really looking at doing anything about it, but.
I wonder if you can comment on the significance or the symbolism of the other side of the Apple-Samsung ruling that came out in, I guess it was Korea, right? Where
There's been a lot of them, so probably.
And my memory was that the reward was, the winner was flipped, but there was no significant financial award. And if you're not familiar with that, I don't want to respond about this.
I'm really not familiar with that one, but if it did it prevent the one party from actually using the invention? Was that what came out of it?
If I remember right.
But that's still a good thing, because really, I mean, for the infringement, getting some monetary compensation, I think, is usually a good thing. But one of the ideas behind the patent is to protect others from using it. So if it protected any further infringement, that would probably be good. But I'm not sure what you're asking me, not being familiar with the case.
It
seems like, I think of patents as a good thing, protecting intellectual property and incenting innovation. But it seems that even a patent regime can be too much of a good thing. There's a point at which it can stymie innovation, so that the shaper of public policy has to use this as one instrument and maybe exercise some judgment in how narrowly and how strictly you can enforce patents. Because there are ambiguities between certain inventions and so many things that can be patented. So at a certain point, if it's patent insurance, it really can be an inhibitor of innovation.
And there's been a lot of discussions along those lines, is in fact, I think, and Booz Allen just recently did a report about, just came out either this month or the previous month, about invention and innovation, and are patents really, what's going on, like you pointed out, with the patents, is that stifling invention or not? And this debate still rages, and I don't think they have a determination one way or the other, but it is something that people are starting to talk about. And I don't think it's gotten to the point where you stifle invention. I think you just have to go about doing what you're doing to make sure that you have the protection. And
so I would imagine that even judges are also oftentimes they're the shapers of public policy, sort of last resort. It always goes to the courts. So even they would have to exercise judgment as to whether this promotes competition, promotes innovation, or not. And sometimes you see in judges' decisions that they are weighing the forces in balance in the judgments. But that's more of a comment than a question.
Right, and I hope that they would weigh that, because the whole hallmark of the U.S. really is innovation and invention. And I think if you lose that, you're going to really lose our competitive advantage in the world as a nation. So keeping that in mind, I think, would be very useful going forward and revisiting a lot of cases and patent law and how things are going to be handled.
At a certain point, though, there's this paradox, because I know with any kind of intellectual development, any kind of idea that's valuable. Back in Newton's days, his great rival Hooke, they would develop ideas and then they would publish them secretly and not share them. So Newton's, this open source approach to scientific knowledge was something that's revolutionary. So it's a fine line between wanting to share things and wanting to have them proprietary.
Yeah, and that's and that goes back to the trade secret too, in a way, because the trade secret says, well, I'm not going to let anybody know a patent's published. So in a way, you are sharing, and that's the fine line you actually proceed down, because if you're going to be sharing it, then you run the risk that somebody can come out with something that's an improvement to the patent, or they'll say, well, I invented this before you did. So you're leaving yourself open. But on the other side is you get protection for 20 years, so that's a good thing.
So the sunset is planned, and ultimately it does become a commodity, whatever is.
Right. And that's, in fact, patents, as I said in the beginning of my talk, is that they are really a commodity, and it gives you a monopoly over a certain commodity, and you can sell it, you can mortgage it, you can leverage it. And so you're absolutely right, it does become a commodity.
Well, I think it's important in this conversation to talk from the public policy piece or from the cultural piece, that the patent mentality here basically comes out of English common law, and it's only embraced by Western industrialized countries. And when we look at that and look at the quantity of people in the world, the majority of people in this world are not in cultures that embrace the whole patent protection business. China and potentially large groups of Russia and former Russia. And so this is a Western philosophy here. And we often try to see this thrusting our methodologies into the reproduction of things in China, and in other cultures that have not embraced the sharing, of the individual protection and individual rights thing?
I think China is coming around a bit, in contrast to, years ago. I'd say maybe in the last 10 years or so, things are evolving a little bit better in China. I think they're understanding the Western point of view and some of the importance of that in going forward and doing business. But there are a lot of strategies there in terms of making sure you have Chinese attorneys in China who are well-versed on your product to help you really protect your patents. And so it brings up another issue, is that getting the foreign patents actually even awarded doesn't necessarily give you the protection you desired. But even in the US, you're seeing that you have issues. So what's going to be really interesting, I think, in the coming years is to see how this first to file versus first to invent actually plays out, because you're talking about innovation, right? And so if you're the first to invent, the innovation concept, I think, holds true a little bit more. Otherwise, it's kind of a race to see who can do the filing first. And then are you going to really forego some of the creativity or even some of the goodness of the product? So it'll be interesting.
But if it's first to file, then at least the clock starts ticking towards the sunset sooner, rather than presumably you can invent something and delay patenting it, and the timeline for it becoming part of the open source, part of the common domain is deferred.
I know you've only been here a little over a year, but I wonder what your opinion is about how good a job we're doing as a university reaching out with expertise on intellectual property outside of the major metro areas, which is basically outside of Anchorage and Fairbanks. There's a dearth of IP legal talent out there, yet there are people who are coming up with very clever, possibly patentable inventions. Are we trying to fix that?
In fact, that's what I'm going to talk about next. So you perfect lead in. So one of the things that I've done my first year here was actually create a business infrastructure to commercialize technology based on faculty and student research at UAA. And what's very, very interesting is that you're absolutely right. There is a wealth of knowledge and a wealth of invention going on here. And since January 2012, I've received over 16 invention disclosures coming through my office, and only 3 the previous year. So it doesn't mean that all of a sudden all these inventions appeared. What it means is those inventions were percolating and they were here, but in part really maybe motivating or putting more of an emphasis on things brought some of that to light. So it's been a very exciting time, and I'll talk a little bit more about that. And what's interesting is that this commercialization infrastructure, and I'll show you a diagram of it, was actually approved by the Board of Regents for the University of Alaska System on July 27, 2012, so just this past July. And so this is a first for UAA, and it's very exciting. And here's the infrastructure, and like I said, it was really put it in place to really help with the commercialization process. And so there's Seawolf Holdings, and it's a holding company, and what it holds the IP for the university to actually invest in startups, and I'll get to actually license rather to startups. And as part of that is Seawolf General Partners, Seawolf Investment Management, but Seawolf Venture Fund is really an exciting concept. And Seawolf Venture Fund will provide seed money for the startup companies in the UA portfolio. And so the purpose of Seawolf Holdings, as I said, is to provide a corporate interface between UAA and its enterprise companies, and really to protect the university, limit its liabilities, and corporate separateness between these startup companies and the universities and the venture fund, hold and commercialize IP, and manage the companies that you saw in the infrastructure that I just presented. And I was actually elected the president of Seawolf Holdings, and that occurred in August. And the board of directors, actually, the members of that are experienced senior level executives who are either CEOs of publicly traded companies or venture firms, and kind of a mix of talent. And I chose that carefully because I wanted to make sure that this board could provide a resource to the university so that it could provide their expertise in helping to decide what quote is commercializable. And so I'll go very quickly. Besides myself, we have Tom Hook, who is the CEO and on the board of Great Batch. It's a publicly traded company on the New York Stock Exchange in biomedical devices, and I had served on their board of directors, so it's only fair that he serve on ours. And Steve Sokoloff, he's a managing partner in New Venture Partners. They're a $750 million fund back in New Jersey. And John Wanamaker is actually a local Alaskan who describes himself as a serial entrepreneur, and he has an active angel investment practice. John Siebert, Dr. John Siebert heads up venture firms, but he also has a connection to Alaska. He was the founding executive director of Alaska Science and Technology Foundation. And Dr. Baker, who's our provost, is also on the board. So I think we have a very interesting board, and we're seeking additional board members. And Seawolf Venture Fund. And I know there's been a lot of questions about this. This venture fund, as I said, will invest seed money in the startup companies. But its investment will be in these areas of biomedical devices, large distributed wireless networks, therapeutic pharmaceuticals, biometrics, and there'll be other areas, all emanating from the University of Alaska Anchorage's portfolio. Okay, so we have a patent portfolio that's growing, and that patent portfolio will actually be the deal flow for this venture fund. And in addition to our technologies coming out of the university, the Seawolf Venture Fund will also invest in companies in the community, or it could be an outside Alaska company. But there'll be certain conditions which have to hold true, and we're still working those out, because this fund is to benefit the University of Alaska, so there has to be a back benefit to Alaska. So either the University of Alaska will have equity in the company that's not from our deal flow, but in the community, or actually have a joint assignment of some of the intellectual property, but there'd be some other conditions. But this will actually enrich our portfolio to attract investors. And so who would we be seeking for this? Well, the target fund size is between $10 million and $15 million, and we're going to do an initial close of $3 to $5 million. And so that just means that once we reach that mark, that then we'll be able to start investing it into companies. And I'm happy to say that we received a letter of intent from the 49 State Angel Fund for $1.5 million. In fact, before I came here, we were just finishing up some of the due diligence for that. So they will be the first investor in our Seawolf Venture Fund. And there'll be a mix of investors from venture capital investment, angel groups, and individuals and corporations. So these are all investors that are outside the university, so that we're not saying the university has to put in money to make this happen. What I'm doing is raising this fund so that we can provide a resource to the university for commercialization. there are a lot of advantages. What we're doing, as I said, this fund is distinguished from other funds in that it has access to a continuous funnel of innovation from UAA, and UAA's patent portfolio is growing. So if you're already not a part of it, I invite you to bring me those invention disclosures. And we have the structure in place. We have a lot going on in the School of Business with entrepreneurship and other endeavors. And Christy, you're doing a really terrific job out in the community. So there's a lot of elements within UAA that are contributing to this. My office is really doing the invention disclosures and the patent filings and applications. So, and really making some of these things happen. UAA is our research is highly regarded, and this is something we don't share with the community very often. We have external funding from major government agencies, NIH, NSF, DOE, NASA. So we're really well positioned to create more inventions. And as I mentioned, since January 2012, we've really increased our number of invention disclosures, and it includes, actually, and I'm very proud of this, it includes 2 students. So we really do encourage students to actually submit invention disclosures either with faculty or even on their own, because one of these inventions here, well, these 2 students did it on their own, but their students are included in a lot of the other inventions. So what's really key to some of these invention disclosures is that they are evolving into patents pending. Some of those are provisional filings or applications, and some are actual patent applications or non-provisional applications. And when I said that we really have the research base to do this, because in FY12, I'm happy to announce that our research grant, that our grant totals were $38.8 million, up 9.8% over FY11. So that's good. We're going in an upward direction, and our trends, I don't have a chart in here, but in some of my briefings, you'll see that there's a trend chart showing that our research funding is on the rise. And what about encouraging and making sure that this deal flow continues or research continues? One of the things that I've done is establish the Innovate Awards, and it's $200,000 a year for seed money for research. And the RFP just came out from my office, and it closed about a week ago. Last year there were 40 proposals and 13 awards, and already many of those proposals have led to successes. And one of the conditions for this award is the fact that your research has to result either in publication in a peer-reviewed journal, it has to lead to intellectual property, or external funding, and really illustrate in your proposal why and what funding agencies or what kind of IP or what peer-reviewed journals. And so, as I said, the new ones are already submitted, and the ceremonies will be in 2012. And also created a patent wall of fame, and the first inductees were actually in December 2011. And the patent wall of fame is hanging in the administration building, and there's lots of room for more inventions and patents. So how I'm going to really wind things up is to, because someone even asked the question, about UAA and what do we have internally, and really getting some of it out. If you look at some of the leading trends that are out there, technology trends and inventions, you'll see that Arctic awareness is one, and that's one that many of the government agencies are now looking at in particular, but there's been an increase or interest in the Arctic. Biomedical sciences absolutely is one real growth area, including medical devices and other areas. Alternative energy, new energy storage is really important, and cybersecurity, big data, and cloud computing, and large distributed wireless sensor networks. In fact, this latter one is a multi-billion-dollar market, which is very interesting. So what I wanted to point out was a couple of things going on here at UAA. And one is actually with our ergonomic rod bender for spinal surgery. And this was actually in the paper recently, thanks to Kathleen. And patent is pending for it. And the significance is that there are approximately 500,000 Americans undergoing spinal surgery each year to correct spinal instability. And the market for spinal implants is $2 billion with a 20% projected increase. And what this device does is it really helps to minimize the time for the surgery and thereby minimizes the trauma to the patient. And if you have spinal correction, the surgeon inserts a rod, and the rod has to be bended to the configuration of your spine. And previously, they would look at your spine and the rod go off, bend it, come back. So a surgeon actually came to one of our engineers and said, well, I would really like to be able to correct this with one hand. So if I could be over the patient and have the rod and the bending device and be able to do it just with one hand, then I could minimize the time for the surgery. And so that was the inspiration, was actually a surgeon. There are other medical devices and our mouth guard to measure the impact of blows to the head, because traumatic head injury is a very important consequence of sports, and it's also important to the military. And we've developed an instrumented mouth guard that can actually measure the blow to the head, but it can do other things too. It can measure some of the biometrics, and that's a real improvement over previous mouth guards. And the ultra lifelong sensing device. And this is a development, and this is a very important sensor because it connects a lot of the things on my technology trend. One, when I said in the left-hand corner of that tech slide that the distributed networks, wireless distributed networks, are a really large market, this fits into that. And what's interesting about this particular sensor is that it doesn't require batteries. It's very small, it's lightweight, it's only $15 to make, a little bit more if you want to add some more capabilities. But the low cost, you don't need the batteries for it. It could last for about 50 years instead of just 5 to 10 years, the usual lifespan for a battery currently. But what's powerful about it as well is that they can be distributed over remote areas. So you can do remote sensing and surveillance. So if you're into Arctic awareness, some of the government agencies are interested in it because you could drop a whole group of these over a really remote area from a UAV and then go back and collect data. And so, or you could put them on telephone poles, or you, for DHS, thought it was interesting because you could use it for border security. And you could pamper a landscape with it. If you pick up one sensor, it tells you everything about all the other sensors. So they transmit as well as receive, and that's one of the nice benefits. If one goes out, it doesn't bring down the network, and you've retained the information because every sensor knows everything about every other sensor. So this particular market is a $13 billion market and an annual growth rate of 5.4%. And so the real trends now for sensors are wireless, small, low cost, low energy, and large distributed networks, which this sensor actually fits into. We already have a patent on an area of biometrics, and that's an eye tracking system combined with iris scan. And what makes it powerful is the combination of two different biometrics. And the biometric market is very large, predicted to be $11 billion by 2017, but the strategies there to penetrate the market are difficult, but our invention has a chance. But in addition, the eye tracking component can be used for learning tools. And our music department is using it to really assess students' skills. So if you're playing piano and you're looking at the measure that you're currently playing, then your skills need to be improved. If you're looking at the measure ahead, then your skills are probably on target. So the eye tracking system, for example, can help determine that. And we have a lot of other inventions, but I think in the interest of time, I will just kind of summarize, one of the areas that we're really moving into are therapeutic treatments, for pharmaceutical therapeutic treatments using Alaskan plants and animals. We have extensive work in ground squirrels and doing everything from looking at problems with obesity to using stem cells actually for stroke therapy and their hibernation characteristics. The Alaskan blueberry has a lot of interesting promise as helping with neurodegenerative diseases such as Alzheimer's and Parkinson's disease, and we have a patent pending in that area. And there's a whole list of future therapeutics based on some of them plants and animals indigenous to Alaska, and others such as Williams syndrome as a result of the really fantastic research our faculty is doing. Just to show you the power of pharmaceuticals, Emory University, you see invested in it through, they provided money for faculty, NIH grants came in, and you could see a trend here that once you get established, the revenue stream is quite good and it's steady. And then you see a spike. And the reason for the spike was that they came up with an HIV drug. And the pharmaceutical company who actually bought out the license from Emory paid $500 million or $540 million for it. So that's a nice thing to kind of think about. And I'm not advocating that our therapeutics will get to that stage, but things like that are possible. So just in a summary, universities more and more are key drivers of economic transformation. And in 2010, jobs from university IP were up 10% from 2009. 76% of the startups had their primary place of business in the licensing institution state. That's very important to Alaska. So investing in IP and encouraging the IP is a good thing and can lead to creating businesses that will stay in Alaska. And Seawolf Holdings and Seawolf Venture Fund can really help enhance the reputation of Anchorage as a center of technology investment. And that's one of the things that can really come out of this, technology advancement and innovation, by growing new business enterprises, attracting corporate investments to our region. And so my final bullet is that if you're not part of the team already, we'd like to see you become part of the team. So any other questions? No?
Thank you for this wonderful, wide-ranging presentation. I think starting from really almost the ABCs of patents and invention and innovation to very much to the institution building that we've gotten underway here at UAA. So I'd ask you to provide another round of applause for Dr. Wisniewski.